Hey y'all. All right, I'm just continuing here from this video series of petition for modification for parenting time, legal decision making, and there is a portion where I shut down child support again. And we're doing my testimony and putting in evidence, and just running through what I have prepared. And so I think at this point in time, we had just gotten back from lunch, or I'm about to try to attempt to play it, and then we go to lunch, then we come back, um, and then we proceed. But we'll go from there. As always, I'm not an attorney. I don't practice law. I don't give legal advice. I'm not liable for anything that you guys do or whatever it is you interpret or take from anything I do or say or any of these videos. This is all for entertainment, educational, and informational purposes only. Do with it what you will, take from it what you will, whatever it may be, and let's go. All right, so here we are. Proceeding from showing the exhibit evidence of when the baby mama was driving, was basically transporting my daughter without a car seat. So I'm in the middle of the courtroom over by uh, the judge's clerk or whatever, trying to attach the HDMI from their big screen or whatever. Just basically getting Exhibit 25 ready. I think that's the one I'm trying to play. I'm away from the microphone as well, in the middle of the courtroom. Um, yeah. So if you guys have been following along, you know that I wrote up what my entire argument was, so that way I had my position, held my position. I had my exhibits ready, so that way I knew where my exhibits would go and with what part of my argument. And so this is how I've been handling myself in court. How I have my arguments, my testimony, everything written down, questions, the things I'm going to say. I stick to my script.
So what we could do is we could take our noon recess now, and during the break you can try to figure out. Let me see if there's an alternative. On your laptop itself, do you have the images stored?
Yes, I do.
If you can verify that they are exactly the same as what is on your sticks, I will use my discretion to allow you to play. Are they
Sorry.
identical? Okay, all right, then I'll accept that if you've got one that works better. The HDMI, yeah.
Yeah, for whatever reason, um, I had made the copies on one computer and then they weren't pulling up on my other computer. And so, just in case, I had all the videos saved on my laptop, so I played them from my laptop, but they were all the same exact thing. I have no reason to change anything, and I provided them the same copies.
This is me picking up loose, Miss Hadley dropping.
So I think we saw that one before. No car seat, right?
Judge, I understand it's a black car seat. I don't agree with his characterization. He can testify.
All right, well, that's fine. I'll accept his interpretation of what he thinks he's seeing, and I'll form my own. I'll form my own opinion in connection with all the evidence.
Thank you, Your Honor.
All right. Okay. So yes, let's take our noon recess. We'll resume at 1:30, where Mr. Quintero will resume with his direct testimony. All right, so we'll stand at recess. Have a nice lunch, everybody.
Oh, sorry, y'all. No, I'm doing this late at night. It's just I get so busy, and I don't. And I know I want to finish this series.
We are back on the record in the matter of David Quintero and
Here we
Kimberly
go.
Hadley,
So
SB 2017-00. We're back from the noon recess on the continued evidentiary hearing on the petitioner's verified petition for modification of legal decision-making and parenting time. Both parties are present. Respondent accompanied by her attorney, Richard Wintry, and paralegal Terry Parrish. Mr. Quintero, are you ready to resume with your direct testimony?
Yes, a quick question. Does that include closing or no?
The total?
The 12 minutes I have left.
Yes.
That includes closing? Okay. All right. All right, just so I know what I got to do here. All right. I'm going to save the videos for later here if I have time. Is 25, 26, 27, and 28 admitted?
25 was admitted?
25 was, yes. And the other three are the same thing. They're videos of exchanges, the same thing.
On which date?
26 is January 27, 2024, before 5 p.m. 27 is January 31st, 2024, a little before 3:30 p.m. 28 is January 31st, 2024, a little before 7:30 p.m.
All right. Any objection to exhibits 27, 28, or 26?
No.
All right. 26, 27, and 28 are admitted.
All right. These four videos of clear and convincing evidence of Ms. Hadley transporting Luz without her safety seat is not only in violation of Arizona child safety traffic laws, but also endangering Luz's physical well-being. And on top of that, she misled the court about it. I think the court should consider a psychological evaluation of Ms. Hadley, and I have a motion here actually ready to go if the court deems so necessary. Number 6, as far as which parent is more likely to allow the child frequent, meaningful, and continuing contact with the other parent, Ms. Hadley objects to all my requests to increase parenting time, and she said so earlier in testimony that she doesn't want me to have increased parenting time. I'm not taking Luz from Ms. Hadley. I filed for equal time. Now that the court has evidence and has heard my case today, I believe the court has just cause to believe Ms. Hadley does not act in the best interest of Luz. Number 7, Ms. Hadley, through her failure to get Luz the therapy she was recommended a long time ago and intentionally misleading the court about getting the help, has caused an unnecessary delay to increase the cost of litigation and to persuade the court to give a legal decision-making or parenting time preference to Ms. Hadley. There's been no Number 8, there's been no domestic violence or child abuse on my part since the last order was entered. But Ms. Hadley has endangered Luz by transporting her 4 times that we know about without her safety seat. Number 9, the nature and extent of coercion and duress used by a parent in obtaining an agreement regarding legal decision-making or parenting time. We have threats of Ms. Hadley and her attorney not following the court order, which is why I have had to file 3 motions to enforce the court order just prior to this, just a few months ago. And then the fact that in the court order of May 2020, there was also a no disparaging clause put in. Ms. Hadley and her attorney have violated that. Luz has told me that Ms. Hadley says negative things about me to her. I believe Ms. Hadley doesn't want Luz to go to therapy because Luz would reveal the negativity that her mother says about me to her. Exhibit 34, please. This email I received on January 15, 2023 from Mr. Wintry here to my right, approximately 2:05 p.m. This is in regards to, we were going back and forth regarding the exchange location, of which I had to file a motion to enforce.
Okay, give me the date again.
It was January 15th, 2024. Excuse me, this year, 4 months ago. It was at 2:05 p.m.
Your Honor, I object if we're not going to do the entire exchange. So this is, as he's indicated, a response by me to him to an email he'd sent. So we can't, he doesn't get to pick half
So
of
it's
it.
out of context with
Right.
knowing the whole conversation.
Yes.
However, out of context or not, someone should not call me a deadbeat dad. And that is in this email from Mr. Wintry to me. There's never a context in where that's okay.
Well, I disagree. I think he is a deadbeat dad, but that's not again, if he's going to offer this, we need to have the entire exchange.
All right, Mr. Quintero, do you have the whole exchange for the email that happened on January 15 of 2024?
Yeah, we have the exchanges like saved in our inboxes, but give to evidence here today, no, I don't, and I don't have time for me. I mean, what am I going to do? Print it out, So
All
no,
right.
I do not. But Mr. Wintry has confirmed his feelings, though, so I'm good with that.
Okay, all right, so Exhibit 34, the objection is sustained. However, Mr. Quintero's testimony will stand that respondent's attorney called him a deadbeat dad. All right, go ahead, Mr. Quintero.
Mr. Wintry is an officer of the court, but that's very unprofessional. I believe he should be sanctioned for that. Ms. Hadley approved this. Number 10, I've attended the Conciliation Court's parenting class several times, plus 4 other parenting courses, including most recently, Exhibit 35, please. What this is 2 separate parenting classes. The first one, Up to Parents, states the date, October 4th, 2022. This specific one is for co-parenting, actually. It's a parenting class for co-parenting. The next one is Triple P, Positive Parenting Program. This is in regards to child behavioral management, which, Luce is having behaviors. She just doesn't have them with me. I'd like these both entered in, please.
Exhibit 35, any objection?
No objection.
Exhibit 35 is admitted.
Number 11 doesn't apply. B, in a contested legal decision-making or parenting time case, the court shall make specific findings on the record about all relevant factors and the reasons for which decision is in the best interest of the child. I have already raised a child and have successfully co-parented with another parent. I've already done this. My oldest daughter has graduated from high school from a school that I picked. I'm her sole legal guardian and have now submitted to the court, to the Honorable Presiding Judge Lee, my 4th annual guardianship report, which has been approved by the court. These are exhibits 41 and 43. They're of the court record. I don't have time to get them in, but it's the court record. The guardianship record and a guardian approval order is of the court record. If I have time, I'll specifically get them in. I'm not a threat to withhold Luce from Ms. Hadley or take her out of the state without permission. I'm stuck in the state of Arizona for life due to my promise and obligation to my oldest daughter. I have the capacity, ability, availability to take care of my oldest daughter's needs with huge success. And Exhibit 42 is a list of appointments that I set and participated for my oldest daughter in 2023. It's about 20, but I don't have time to get it in. If I do, I'll get it in later.
Okay.
I am more than capable, able, and available to make legal decisions for Luce, but what I'm not going to do is delay getting Luce the help she needs. I would actually put Luce first and make sure all her health, safety, and welfare needs are met. Under ARS 25403.01, it is Ms. Hadley's lack of agreements and inabilities to co-parent and unreasonable and are influenced by issues not related to Luce's best interests. I have examples of co-parenting by immediately informing Ms. Hadley of Luce hurting herself at a playground and bike riding, because I'm transparent. That's Exhibit 49, but I don't have time to get it in right now. They're just text messages to Ms. Hadley telling her Luce fell at a playground or Luce hurt herself like on her bike. And I send her these text messages. Under ARS 25403.02, the court shall adopt a parenting plan that provides for both parents to share legal decision-making regarding their child that maximizes their respective time. I'm checking my time, sorry. I outlined this in the parenting plan I provided and gave the court 3 options. Ms. Hadley submitted no parenting plan. Well, apparently they did. I got it last night. I haven't had time to see it. As far as the court's intent to follow the incremental increase of the parenting plan, we have followed it. We are currently in the last phase of it with no more phases, nothing more to increase. I am also willing to continue with an incremental plan that leads to one of the plans that I have outlined. However, due to what I have proven here today, Luce's best interest, I believe that the court can consider awarding me sole legal decision-making. Now, whether joint legal decision-making arrangement is logistically possible, Ms. Hadley's strategy to refuse to co-parent with me in order for the court to maintain Ms. Hadley with legal decision-making is a strategy that she's used. However, it's unreasonable. In her unwillingness to compromise, she hasn't been helping Luz and has endangered her physical well-being. It is in Luz's best interest that I have sole legal decision-making, or at minimum, ordering joint legal decision-making with I having final say. There should be provisions in place that allow Luz's relationship with her father's side of the family. While we're at court, we should consider ordering parenting classes for Ms. Hadley, specifically regarding dealing with child behaviors and a focus on co-parenting. I have provided this court more than enough testimony and evidence that meets the equal custody standard and legal decision-making. If I don't get any legal decision-making authority, I beg this court to order Ms. Hadley to get Luz the therapy she needs, because without an order, she's not going to do it. I have 2 minutes left. I will try to get in, see whatever it is I can play, and then you could just cut me off when I run out.
It wasn't on here because I made changes like date of. I added some things and made some changes, and then obviously with my time being so short, I had to cut some things and all that.
Well, go ahead. He can tell me whatever he wants me to know in connection with it too.
So, as you heard, I went down the whole list here because this is what they're making their decision on. I went down this whole list, and then also went down the other legal decision-making factors, which I was naming in here, which was these, right? ARS 25-40301, ARS 25-40302. I just covered all bases.
Hi.
Where's the car seat? Where's the car seat? Where is it? It's not there. There's no car seat. They know what they saw. He's just
So
thinking.
was that exhibit 26? Or was it 27?
27.
Okay. You've used about 58 minutes, but I'm going to let you play the other videos just to have you finish up this subject that you want.
Remember the stuff I gave you? Or the stuff you have? Here.
Where's the seat?
It's not there. So you can set that down.
Is that your timer? Well, go ahead. You can finish your...
That's my timer going off.
She didn't want to eat. So, bye, Luz.
You saw it there. That's what they saw. It's indisputable. It's obvious. There was no car seat. 4 times. The court didn't care. They don't care. Just letting you know ahead of time. I didn't know then, but I found out afterwards that they didn't give a flying fuck. They didn't care. So, best interest of the child, my ass. They don't care. They don't care about kids. It's never been about the best interest of the child. It's always been whatever the mother wants. That's all it is.
No, I saw each of your videos that you played. All right, did that complete your direct testimony? All right, you're welcome. Mr. Wintry, do you have cross-examination?
I do.
Okay. Now he's going to come after me. Here we go.
Oh, you can take a seat, Mr. Quintero. Thank you. And Mr. Wintry, if you're ready, go ahead with your cross.
Let me go ahead and ask Mr. Quintero to have a seat in the witness stand.
Oh, all right. Mr. Quintero, you can testify from the witness stand while Mr. Wintry's doing his cross-exam.
So what color is the booster seat?
I've seen it before, so it's black.
Okay, we can agree that the seat is black. These videos that you just played do not have the time stamp, does it? Do we see a time stamp on the videos you just played?
No, but
Okay.
we know when our exchanges are.
I don't need an explanation. The no answers my question, Mr. Quintero.
Sure.
Does that make sense?
Yeah.
Okay, so we don't know whether that exchange occurred at the time it was scheduled or if somebody had to wait, do we?
At the time it was. Oh, I said it was.
I didn't ask what you said.
Okay.
I asked, in looking for a timestamp, you agreed there is none, didn't you?
There's not a timestamp on it.
And so if you were a few minutes late, if somebody had to wait, if we don't know
He's
that
just
based on
creating doubt.
timestamp, do we?
No.
All right. My client's testimony is that when the child, Luz, was required to wait, she would squiggle out of the car seat.
She never said that.
The booster would end up down on the floor, and she would, occupy herself until you arrived.
Who does that? Who does that? Please tell me. Who sits in a child seat and gets out of it, moves the seat, and then just plays on the floor? He's just creating doubt. He's just saying nonsense. But it doesn't matter because the court did nothing. I showed clear and convincing evidence.
And the exchange took place. Did you hear my client's testimony in that regard?
No, not that way.
All right, fair enough. The events that we've seen on the video, do we have any idea what was happening before you turned the video on?
I was waiting, and
do we have any idea from the video what was happening?
A second. I don't think Mr. Quintero had finished his answer. You asked him what was happening before.
We don't know what was happening before the video was
turned on. So he was saying he was waiting, and then were you done with your answer, or were you?
I was not.
Your Honor, I'm sorry, his answer was not responsive. I didn't ask him what he was doing before the video. I asked him, do we have any idea of what was occurring before the video? He turned the video on.
Okay, well, maybe I misheard the question, but it's essentially, can you describe what was happening before you turned on the video?
I was waiting. There's only so long that I could record, and so I don't start recording until I see Miss Hadley pulling in. So when I see her pulling in, that's when I hit record. When she's dropping her off. When I'm getting off of the bus, usually she's already there. And when we're on the bus, I look over to see if she's already there, so I turn on the video. So,
either way, did any of these recordings show you walking up from the bus stop?
No.
Did any of the videos show Miss Hadley pulling up?
Yes.
Which one?
Two of them.
Should I play them?
No.
Okay.
The fact is, none of them showed Miss Hadley pulling up and you walking up to the car and Luz popping out, did they?
Yes, they did. I can play them. I don't recall which one, but I can play them.
All right, but you agree it's only one?
I can play them. I'm under oath, so I want to be completely honest. I can play them.
And your testimony was, I don't know which one. So is it your testimony only one of your videos shows my client pulling up to the curb?
Two of them, because two of them were, she pulled up, I was picking Luz up, she left, right? And so then there was a drop off. So the video was later on, you see? So one of them was approximately like 9 a.m. in the morning, right?
Wait a minute. You're giving me information that has nothing to do with my question.
Two of
Your
them,
testimony under oath is two of those videos show my client pulling up to the curb
yes, they are. Two
with
of
you
them.
walking up to the car.
Yes.
All right. And one of them does not show it at all. And none of them show you coming from the bus stop up to the car. That's your testimony, right?
Two of them.
Don't worry about it. You're having a hard time answering yes or no questions. The testimony that Luz unbuckles while she is waiting for you, that she unbuckles herself so eager to see you and is climbing out of the car seat. You heard that testimony, didn't you?
I heard Miss Hadley say that, yes.
All right. And of course, the videos don't show us one way or the other whether that's happening, does it?
It does. The two videos when she is arriving, she is driving up. I'm recording at that time. She's driving up. She stops. Luz opens the door, gets out. I played two of those actually, and there's no car seat. And then two of the others are when I'm dropping her off, and I'm handing something to Luz. She's putting her stuff inside.
Sure.
She gets in there, no car seat, close the door, and that's specifically why I waited for her to drive off.
Okay. So my question that you have not yet answered is, do the videos show whether Luz unbuckle herself from the booster?
She can't unbuckle herself from a booster seat she's not sitting in.
Mm-hmm.
Okay. So your answer to my question is, that's right, Mr. Winter. They do not show Luz unbuckling herself from the booster seat, right?
There's no booster seat, so...
Well, you're
I don't
testifying
understand.
to that. The court has the videos. Here, look. Now, I appreciated you're referring to the controlling statute, 403 and 40301, as well as 40302. Cite me which provision analyzes the use of booster seats.
Arizona state law.
No,
that is separate.
Which provision of 40303, 40301, or 40302 references booster seats?
I would have to check because I have the statutes right there, but it says all relevant factors regarding the child's safety and welfare and...
All right, so you're acknowledging that the only manner in which booster seats plays a role here is under one of the general provisions that calls upon the court to consider all relevant factors. Is that your testimony?
Yes, it is. It is relevant.
So we can, under the general provision, you would agree there's no specific provision that requires the court to reach factual determinations regarding the use, non-use, or the manner of use of booster seats, right?
Yes, that is correct.
You testified to some length that you acknowledge the error of your earlier claim that my client had gotten no therapy for Luz, and that in fact she had gotten the speech therapy for Luz.
Yeah, I gave Miss Hadley credit for what she did do, the one thing she did.
Could we confirm that that contradicts your earlier claim that she got no therapy for Luz at all? You remember saying that?
I did say that, and then subsequently, after I learned through discovery, thanks to your paperwork, that she did get the speech therapy, and then that's when I made the emails to find out if there was anything more, and there wasn't.
So the answer to my question is yes, Mr. Winter, that's right. My acknowledgement that Ms. Hadley obtained the speech therapy does contradict my earlier claim that she had done nothing to get therapy for Luz.
In that manner, as far as the way you put it, yes, sir, that is correct.
You also failed to acknowledge the group therapy that Luz received through her school, didn't you?
That's not my evidence to present.
Do you deny the truth of it?
I don't know of group therapy. I honestly didn't look at any of your Well, not any of them. I looked at some of your exhibits, just the ones regarding
Let's
therapy.
just stick with what your claim was, that my client had done nothing to get Lou's therapy.
Not those specifics. No, the specifics outlined by reflections therapy. She did none of those except for the speech therapy.
Okay.
And then the ones from the pediatrics, she didn't do that either.
Your claim was that my client did nothing to obtain any therapy for Lou's. That's what you've said several occasions, haven't you?
Asked and answered. That's what I should have said.
And then 2 questions ago,
No,
you
I had
asked.
2 questions. The answer is yes or no. Your position statement that my client did nothing to obtain therapy for Lou's.
I stated that Ms. Hadley gets credit for having obtained the speech therapy. She did one thing.
Okay. And you deny that she did anything to obtain other therapy for Lou's. That's been your position.
I deny it with the evidence of her teacher saying she didn't get it, with the school saying she didn't get it, with Laura Kutowski saying that she didn't get it. She specifically said that all she does is areas of communication. She's not a counselor or she has her master's in education. I looked up her title, but all she does areas of communication. It's in the email. It's in the exhibit submitted, sir.
This court is considering evidence. I want to ask you to take a look at Exhibit W.
He just moved on. He couldn't get what he wanted.
I'm moving. Your testimony is, I'm sorry, I didn't catch it. Your testimony has been that my client did not obtain group therapy for Lou's. Is that your testimony?
No, my testimony, and I was very specific of the 5 things. I don't know that, to be honest with you.
So you don't deny it, you're saying you don't know.
I do not know. No, sir.
All right, so if my client did obtain group therapy for Lou's, that would also contradict your claim that she did not obtain needed therapy for Lou's, wouldn't it?
No, that's not correct, because there was very specific therapies.
Let me hand you Exhibit W.
He's asking the same question differently. The same thing he was doing with my sister. He just wants the answer he wants. He wants the answer he wants.
You want to go for W?
Let him finish looking at it and I'll find out if there's an objection.
Okay.
Any objection to Exhibit W?
No, that's fine.
All right, Exhibit W is admitted.
I think it was.
So now that you've had a chance to look at W, do you need to amend your statement that my client did nothing to obtain therapy other than the speech therapy for Lou's?
No, not exactly. It says Rachel Walters, MED. That's a master's in education. That has nothing to do with counseling, specific therapies. I mean, I see a couple things on here, none of which is specifically identifying Dr. Sobadoya's recommendations and including the recommendations from pediatrics. So, no, sir.
All right. So your testimony is that this does not indicate that anything beneficial was happening for Lou's in terms of helping her deal with the stress of this circumstance. Is that your testimony?
No, it is not, sir.
All right, well, let's take a look at it and see if we can sort it out. Take a look at page 2. Let me know when you're there.
Okay.
Ms. Walters, the MED, I left you a voicemail earlier today. I offered kindergarten students extra support in a small group called Making Friends and Managing Emotions. The group starts Monday, so I wanted to see if you give me permission to include Lou's in the small groups. I poll her during the day for 30 minutes, once a week, 5 sessions. I have a wait list, but fortunately, I could get Lou's in this first group if you like. Does that sound like something that would benefit your daughter?
Yes, but it's not the specified recommendations by Dr. Stobadoya or by the
All right, so let me make sure
pediatrics.
I'm understanding, because you're really helping us sharpen up this issue.
It's important.
If it was the Stobadoya thing, you'd be good, as you are with the speech therapy. Any other therapy, though, that is not specifically in Stogodoya doesn't matter to you.
Yes, it does. I think it would be. So this is a good thing.
All right.
Yeah.
Let me stop there.
Yeah.
You agreed this was a good thing.
Yes, it was.
That it was therapeutic.
I agree that it is a good thing.
Making friends and managing emotions, a good thing.
Yeah, these are good things.
All right. And you agreed that it was my client reaching out to her teacher, master's, God forbid, but a master's. You acknowledged that it was my client who initiated this, made it happen, right?
Yes, she just hasn't done the rest.
I get your criticism, but I want to celebrate the acknowledgement that she did get the speech therapy. She did get her into small group therapy by a professional, helping her with emotions and making friends. We're agreed on all that.
Of course, this is for Luz. I'm all for this.
So,
it's just not enough.
Now, this court's ruling, June 15th of 2023, this court's ruling included a finding that the court does not find good cause to require a new therapeutic evaluation of the child before the petitioner progresses to unsupervised parenting time. Do you happen to recall this judge making that finding? That there was no additional therapeutic evaluations that were required before Luz and you went to unsupervised parenting time?
Well, because we had already done it. There's no reason to do that. She made her recommendations.
So you're saying you agree with Judge Wood's finding? You personally, she can be celebrating the fact that you, Mr. Quintero, agree that she made a right ruling on June 15th when she said there is not good cause to require a therapeutic evaluation of the child.
Because she had already had one. We would be doing the same thing twice.
We're chasing each other's tail. Therefore, because you believe it had already been done, you agree with Judge Wood's finding.
Yeah, I agree that.
Thank you. I'm sure that makes the court feel good that you agreed with her decision. What I'd like to do is ask you, in the review of the factors, and we both agree that the court should apply the factors in 403, 403.01, and 403.02, right?
Yes.
You ran through those factors in your testimony. You included in 403.01 the past, present, and potential future relationship between the parent and the child, along with 2, that the interaction and interrelationship of the child's parent or parents, the child's siblings, and any other person who may have a significantly affect the child's best interests. You remember talking about both those factors?
Yes, sir.
You mentioned that you've had success raising a child. Is that right?
Yes, sir.
You're talking about your older child, Valerie.
Yes,
Now, you became the child's guardian, Valerie's guardian, at what age? How old was Valerie when you became the child's guardian?
18.
Her majority, 18 years of age.
Because I became power of attorney first, and then I had to file for the guardianship.
When she was 18 is what you previously testified to. Are you suggesting you did it at an earlier or a later date?
Hold on.
By the way, did you notice the term that he used, the age of majority? Yeah, so when it comes to, age of majority, when someone's an adult, other than that, everybody's, they're all a child. And then, you know what I mean? This is just the little sprinkles of the common law stuff, and the terms and the legal terms that get used in that. Just throwing that out there in case you guys didn't notice.
I'll be completely honest with you. I don't recall exactly what age. If I had said 18 and I was wrong and it was 19, that, it's not to mislead or anything like that. But
you don't need
fact
to
remains,
speak, partner. Nobody's accusing you of that. So 18 is good enough.
Well, for the past 4 years, because I
So
submitted my 4th
let's
guardianship
say
report. So
for the first 18 years, give or take, in Valerie's life, what was the decision-making order with regard to her?
Oh, her mother had it?
Had joint?
No, she had sole
She had sole legal decision-making.
Mr. Winter, you're kind of jumping in over the answer, so let's try to allow the full answer before your next question.
Yes, Your Honor.
Thank you.
Go ahead, finish.
Yeah, her mother had sole legal decision making. We had one hearing in court because We co-parented.
You answered my question. You testified, though, that you had success in raising your oldest child.
Yes.
You remember testifying to Judge Woods that?
Yes, you don't need to have legal decision making to raise a child.
But the truth is, you did not have joint legal decision making. You did not participate equally in the raising of Valerie, did you?
I did not have joint legal decision making, and I also went through a scenario where
you answered the question. You don't need to go on. The point is, you told the judge you wanted to claim credit for successfully raising Valerie, but you did not have joint legal decision making. Her mother had sole legal decision making, didn't she?
Yes, but I still raised that girl.
Your testimony is, so would you agree with us then today when it comes to Luz, that if my client retains sole legal decision making, you will still be able to parent her in the same manner that you did Valerie, right?
I will do my best. If not better, I've become a much better parent. I'm superb in my parenting.
Okay, so the answer to my question is yes. So the point here is, you agreed and that your claim to Judge Woods that you were a successful parent for Valerie was present even though the mother had sole legal decision making. You didn't have joint. You really had nothing. But you were a successful parent to Valerie. That's your testimony now.
No, it's not. You said I didn't have nothing. I never said that. Her mother and I co-parented. We came to court one time in 18 years. That's called co-parenting.
Your testimony is that legally you did not have joint and she had sole.
Yes.
And you have testified a couple of times now that you successfully parented your daughter Valerie, right?
Yeah, co-parented with her mother, yes.
You call it success. So, if the court continues to follow every other judge that has reached the decision in this case, that my client retains sole legal decision making, that is not going to prevent you from successfully co-parenting, right?
No, only Ms. Hadley is going to prevent us from co-parenting.
That's your concern. But as far as the legal orders, sole legal decision making does not prevent you being denied joint, her keeping sole, will not prevent you. The legal order will not prevent you from co-parenting Luz. True?
I don't co-parent with Luz.
Okay.
I am a father to Luz, and I am her parent. We have a parent-child relationship.
You answered the question as best I know you're capable.
Thank you.
So, the factor of your description of the relationship you have
He's
with
asking
my
the same
client,
question, just differently. He wants the answer he wants.
Status is the past, present, and potential future relationship. You understand that it's appropriate for us to look at your past relationship with Luz and with my client. Do you accept that?
Of course, we can go back to the last order entered.
Let's go back to your kidnapping your daughter. All right. Now, you seem to object to the word kidnapping because you were never criminally charged with kidnapping. Is that true?
That is true. I was not charged.
You weren't charged. You weren't convicted. You didn't go to the penitentiary or even to jail for kidnapping, did you?
Which is true, which is slander if you
That's
use
all
that
true.
word.
Now, has a judge ever found, after hearing evidence in a contested hearing, that you kidnapped your child?
You said contested, so no, not contested.
Right. The first time you were found to have kidnapped your child was in an uncontested hearing. True?
Yeah, it was uncontested. I wasn't present for it.
And why were you not present for the hearing where Judge Green found that you kidnapped your daughter?
Because I wasn't allowed to address my emotions. I didn't know what was happening at the time. And I was myself for an attorney, and I gave myself bad advice. I didn't know what I was doing. I know ignorance of the law is not a valid defense, and I made a mistake.
I want to give you an opportunity to tell the truth, because you know this is all findings Judge Green made. Do you want to really testify under oath right now that the reason your hearing was uncontested is because Judge Green would not rule on your motions, or do you want to tell Judge Woods the truth, why you were absented from that hearing?
I wanted to address something, and I brought it up a very specific way, it was not the way Patricia Green had wanted the things to go, which was the proper way for the court to go. So I made the mistake, and she did kick me out, but of the hearing. But it was because I wasn't doing what she asked. I did do that. I take responsibility.
One last chance to tell the whole truth. Not all these words you're saying, the whole truth. What was the particular thing you did that caused you to be absent from that hearing?
I had told her I was reading a script that I had. Maybe you need to be specific. I'm sorry.
You refused to be sworn to tell the truth, right?
Okay, yeah.
So, a custody hearing is not an administrative hearing. You can't challenge jurisdiction at a custody hearing in the same way you can challenge jurisdiction at a child support hearing. So this was a couple years ago. I was using a strategy I shouldn't have used. However, when it comes down to it, I still wasn't properly served, and the judge never addressed my motions. I should have said something differently here. However, my mistake is I had a script for dealing with administrative for child support with all that that I used at a custody hearing, and that's not what you're supposed to do. Custody is a constitutional issue, and the child is born in the state, and if you're there in the state and child has the home state and all that, you need to play their game. You need to play their game. There's no other way around it unless you have a private agreement with the baby mama, and that's how I came to find that out. So let's see. What's going on here? Hold on. 43. 1 second. Well, I gotta reopen it. There we go. I was about right here.
What was the particular thing you did that caused you to be absent from that hearing?
I had told her I was reading a script that I had. Maybe you need to be specific. I'm sorry.
You refused to be sworn to tell the truth, right?
Okay, yeah, that was one of the things. Yes, sir.
It wasn't one of the things. The reason Judge Green gave in the record why you were going to be excused from the hearing is that you refused to swear to tell the truth. You refused to take the oath. Isn't that true?
I did refuse to swear in during that hearing, and
okay. And in fact, that was not the first hearing in this case, not in front of Judge Green, but it's not the first time you refused to take the oath.
No, it's not.
You've done it in earlier hearings, haven't you?
Yes.
So it's not like
Didn't
when
matter.
Judge
That was
Green
the child
let
support
you know
hearings.
we're going to have to take the oath to continue to participate in the hearing. That was news. You knew that was going to be expected.
I didn't know what I was doing. I was reading a script. I apologize for that, and I paid the consequences severely for those actions.
Well, one of the consequences is that when we're looking at your past behavior and conduct, is it led to a hearing where...
Okay. All right. So, yeah, we're going to come back to in the next part where we finish up here, where he's cross-examining, and then that's where he brings up child support, and I shut him down. You'll see. All right. Catch you at the next one.